Prakash Sharma ji has a history of pulling unprecedented feats. During his glory as a president of Delhi Bar Association, which is Asia's largest bar association, he ensured that there was no strikes at the bar. And for that, he was known as a man of stir and not of strikes. So something that he had been thought of impossible considering the environment at the time when he has took over has been possible by his steps towards the same. He has shown his devotion towards the supremacy of the bar and taking the important issues with the bench. Sir, we welcome you today on the board. And with him we have Shri Sanjay Rathi ji. Again, nothing more to say about him. He is also a co-chairman of our own Bar Council of Delhi. He has started his practice in the year 1995. And as we all know, with the bad impact of the COVID-19, which has done in our city, he is really at the forefront of confronting the problem on behalf of the lawyers. Aside from his services at the bar, he has also been remain an additional advocate general for the state of Haryana at Supreme Court. And he was also the former standing counsel for the Union of India. Sir, we welcome you also on the board. With this, I take the opportunity to hand over the today's webinar to Dr. Amit George, from where he will set the stage to start with the discussion, which is very important and to be heard by all the bar members which are waiting for this important issue to be discussed. Dr. George, over to you.
Yeah. Right. Thank you so much, Nitesh, and a very good evening to everyone. We are gathered here today in the backdrop of possibly the greatest existential challenge to confront the legal profession in modern India. To put the matter in perspective, in a survey carried out in March in the relatively early days of the pandemic by the Bar Council of England and Wales, it was found that over half of barristers' chambers will not survive the next 6 months without financial aid if the COVID-19 outbreak were to persist, while a whopping 81% would collapse if the outbreak were to continue for longer than a year. This is the stated position in a legal system that is far more evolved, has a far lesser number of practitioners, and more importantly, witnesses far lesser disparity in the level of earning within the legal fraternity as compared to our own system. Now, at the risk of sounding like an alarmist, when we try and apply these already worrying statistics and as to what they portend to the legal profession in our country, things look even more bleak. Unlike some of us for whom the greatest consequence of the COVID-19 outbreak might be a feeling of boredom or professional listlessness, the majority of our colleagues do not enjoy such a luxury. With the continuing suspension of the normal functioning of the courts and the consequent lack of access this signifies for advocates, there is a grave threat to the continued survival of the bar. This threat operates on two levels, namely the personal one, with many advocates struggling for basic subsistence, which is evidently a serious problem, which we may call the problem of survival. But what we usually overlook is the problem on the institutional level, with the possibility of a large number of legal professionals quitting litigation altogether and thereby leading to an exodus. This potential exodus is equally serious in as much as it severely compromises not only the total numbers, but also the diversity and inherent health of the bar, which is otherwise well served when persons from various walks of life and diverse socio-economic backgrounds become a part of it. While we look for solutions, one must, however, also bear in mind and seek to balance the risk that a physical reopening of the courts would represent in terms of the potential for infection. There are really no easy answers. However, it is in times of grave crisis like this that the Bar Council of India can really transcend beyond being a mere regulator of the profession and instead fully exhibits its potential in being a dynamic and responsive representative entity, which is able to truly advocate the cause of its constituents. It is in this representative spirit that the main speakers and the organizers of the event have kept the same time for questions from participating lawyers as has been allotted to the main speakers. I hope that the present session represents for the bar not only a symbolic representation of hope, but also a concrete platform to find a solution to this massive challenge that confronts all of us. Thank you to Nitesh Mehra, Mr. Angel Bharadwaj, and Mr. Mayank Garg for putting this together. And now on to our main speakers. Welcome, sir.
Thank you, Dr. Amit George. Sir, I would like the opportunity to call Shri Ved Prakash Sharma, sir, who is the co-chairman of Bar Council of India, to throw the light on the subject. Sir, over to you.
Thank you. Thank you very much. Good afternoon, friends. Mr. Sanjay Rathi, Co-Chairman, Bar Council of Delhi, Nitesh, Dr. Amit George, Mayank Garg, Angel Bharadwaj, and my dear friends present in today's webinar. Firstly, I thank the organizers, Mr. Mayank Garg and Nitesh and Dr. Amit George, for this opportunity to share my views on a subject that has captured the thought process of each member of legal fraternity, not only in India, but across the world. 213 countries in the world are grappling since several months now with the coronavirus pandemic COVID-19. Alas, without any success in sight so far. The pandemic has spelled doom on every sphere of human life. It's a catastrophe. It's a disaster unexpected, never seen or heard before. Ever since national lockdown was put in place, all industrial, business, social, and professional activities came to a grinding halt, and every individual is facing the heat of corona. No wonder lawyers across the country also are facing problems, pain and plight of sorts, and going through a most distressful and difficult period of their lives. Legal profession, legal professionals, and justice administration system is enormously hit. Dr. Amit George has very eloquently put this aspect of the problem before you moments before, and he has very well explained the problem which is encountering not only advocates, legal fraternity in this country, but also in other countries which are even developed countries. And the question is now becoming for many of lawyers a question of survival. With court work being suspended, with no access to their law offices, court chambers, bar rooms, lawyers are rendered without any work. India has about 17 lakh advocates. An overwhelming majority is suffering. Several hundred thousands are rendered unable to make their ends meet. As per the data collected by Bar Council of India, nearly 3 lakh needy advocates applied to different state bar councils for financial assistance during lockdown period. Disbursal of funds to the applicants is already made in most of the state bar councils, while in others it is under process. Bar councils have availability of limited funds. There is no state grant to bar councils, so we can't meet the aspirations of all needy lawyers. Bar councils can't ameliorate the suffering of all, but still they are doing their bit. In the process of disbursal of financial assistance, and ex gratia aid of about 100 crore rupees is expected to be given by all state bar councils in the country to needy advocates. Delhi Bar Council is on top in the matter of providing financial aid. About 9 crore rupees is the likely amount Bar Council of Delhi would end up giving to needy lawyers. But my dear friends, lawyers don't want charity. Lawyers want to work and earn. And you will appreciate that ex gratia payment, financial assistance by bar councils, lawyers and the needy lawyers, we do have a certain amount of advocates, almost 3 lakhs, 300,000, just I told you, they have made application to the bar council. How difficult it is for a professional, for an advocate to approach the bar council or any, for that matter, organization who is the regulatory organization for financial aid, saying that, so see, I am not in a position to meet both ends meet, I can't make arrangement for my basic necessities, provide me some financial assistance. It's really very pathetic, very painful, and you can't describe this situation in words. Very, very difficult. Now, the next question is that this corona, this pandemic, the situation, the government was not wrong when the government claimed this lockdown. Everything came to a halt. The courts were also closed. But how long can it continue? Now we have seen the working, we have seen lockdown 1, lockdown 2, lockdown 3, lockdown 4. Now it is almost 60, 65 days now. Courts are not functioning. Now, after the lockdown 4 will end today, but after it comes to an end, there is already an announcement made by the Home Ministry that many sectors are going to open. But there is no word till now about courts. I'll come to that later on. But before that, let me come to virtual courts, which is the other subject for discussion today. Now, this virtual court, video conferencing court, or digital court, as it is now widely known. Now, when lockdown was imposed and normal and traditional court functioning stopped at all levels, from the Supreme Court to the lowest court, orders were passed by the Supreme Court and almost all high courts that hearing of most urgent matters only would be allowed through video conferencing. But then what's the video conference hearing? How long can it go? We have been
आवाज नहीं आ रही यार।
एक्सक्यूज मी सर, आवाज नहीं आ रही सर।
आ गई।
ओके सर, थैंक यू।
Ved Prakash sir, can you hear us? We cannot hear you. Mayank, can you check with us, sir, please? Mayank.
Sir, not audible, sir.
Mayank, can you check with us, sir?
Yes, Mehra sir, just a minute. I'm checking.
Okay. I request all the participants to remain on hold.
Just a minute, Mehra sir, I'm just checking.
Sorry for the interruption. Something went wrong, and this is the problem that even in video conference call, this is the usual problem we are facing. So I was telling you about the functioning of this video conferencing courts, this virtual court or digital court. I told you that we have done some research work, and we have collected data from all over the country through our state bar councils. Almost 80% of the total pendency of court cases in our country are trial matters in district courts. Appeals, revision, writ petitions, etc. would fall in the rest 20%. The most urgent matters among these would be hardly 10%. Thus, only 10% cases qualify for hearing these days through video conference or virtual courts. Now, the feedback that we have collected and from various high courts and district courts in the country is that not all requests which are made for listing the cases in this category before the video conference court are adequately entertained. And we have come to know about 2 to 3% cases only succeed in getting listed before this video conference court, because there is a procedure. You have to first file, do the e-filing, then you satisfy the officer concerned that it falls in the category of most urgent or urgent matters, and hardly 5 or 4% people succeed in getting their matter listed before the video conference court. And the harsh truth, that we have come across is that only a few limited number of people, they get access to these courts through virtual hearing, and the cases of only a few fortunate persons, privileged persons, are being fixed before these courts. Now these facts are coming from different states, and we have, with a sense of responsibility, written all these things to the Chief Justice of India, and to convince him that sooner or later we can't wait anymore. The corona is going to stay. We have to live with it. So kindly find out some solution that traditional courts can start functioning. This is what we have stated in this letter to the Chief Justice of India. Now, what is the fact? The position is that when about 90% matters are languishing in courts without any hearing, because only 5% matters are going before the VC, video conference courts, and that to most urgent or urgent matters. So ordinary matters, they account for 95%. They are languishing in courts without any hearing. It also means that almost 95% advocates are without any court work and without any court appearance these days. So it naturally indicates that almost as many judges as well have no court work these days, and their valuable time is left underutilized, as they are either sitting at home or in court chambers and not able to attend to any judicial work. Now this is a harsh truth, and these are facts which are collected and reported to us by various bar councils, including our bar council. Now, my dear friends, there is another issue. The issue is lack of knowledge and training in technology, lack of technological infrastructure, and also due to the law and procedures of dispensation of justice in trial matters, that video conference can never be suitable for dispensation of justice system in our country. Now, just one hard fact which you will appreciate, because we are all practicing advocates. We have practiced in the trial courts, that this misconception or conception about VC court would be demolished just by one fact. As far as trial courts are concerned, we can't even imagine a trial court work being done through virtual, because the recording of evidence is a very essential ingredient, in the trial court system, and therefore recording of evidence of witnesses exhibiting documents, confronting witnesses with documents, watching the demeanor of witnesses, and above all ensuring that the witness is deposing without any pressure, without any coercion or undue influence, are some salient features which a traditional court only can ensure, and these things can't be ensured and guaranteed in a virtual courts. So such is the law and procedure in our country. And as I told you, 80% matters are trial court matters. So we have to take note of this fact, and this is what we have been trying to do, and while making approach to the Chief Justice of India. Now, my dear friends, I had the occasion of going through a statement given by Honorable Law Minister of India, Shri Ravi Shankar Prasad, just a few days back, when he stated that the future belongs to digital courts. Now, I seriously differ, and rather we differ. All bar council, state bar council of India, we seriously differ with our Honorable Law Minister on this issue. Now, traditional court, physical courts cannot be replaced, cannot be displaced by digital court. As I told you, there are so many practical difficulties, and which is not possible to remove all these things. Lack of infrastructure. How can you say that the future belongs to digital court when there can be no assurance that a proper evidence can be recorded before a virtual court? And without recording of evidence, you can't imagine a trial. Evidence, this examination, cross-examination is soul of a trial. And these trial courts are soul of the judicial dispensation system of our country. So we can't afford to say that the future belongs to digital court. In my view, the past has always belonged to traditional court. The present also belongs to traditional court. The future will also belong to traditional courts. And yes, as far as IT is concerned, yes, IT has become a very important and essential part of our system. And in our legal practice, lawyers and judges, they all take advantage and benefit of IT in research work, in other things. So it is very beneficial, no doubt about it, but we can't convert it into a virtual or digital court to come to the conclusion that dispensation of justice, administration of justice in this country can be taken care of through this court. My dear friends, as far as the opening of court is concerned, I must revert to that subject because we are in touch with Chief Justice of India on this issue. And we met the Chief Justice of India yesterday. Our chairman, Mr. Manan Kumar Mishra, was there, and I was also there. Some of our Bar Council of India members met him, and we have pleaded the case that since now lockdown 4 is going to go, and we have to live with Corona, all other sectors are opening. So you kindly ensure that courts also start functioning because lawyers are in a dire strait and in great difficulty. Now the Chief Justice of India has taken feedback from different high courts in the country. And as you know, we all know that courts are a crowded place. In Delhi, we know almost every court complex, every district court in Delhi would have a footfall of about 30 to 40,000 lawyers every day. So there are some issues, and the suggestion which we have given to the Chief Justice of India is that in the beginning you kindly do one thing. You kindly start this traditional court, and as far as this the most urgent and urgent matters are concerned, you start with them, and you make it optional for an advocate for a party to go either before the virtual court or go before the physical court. You kindly list only 10 matters in a day for about 15-20 days, 2-3 weeks, and then you see the performance, whether the social distance kind of norms and the kind of these precautions are being properly taken care of, and whether this is going to succeed in the proper kind of perspective. So this is what we have suggested, and we have been assured by the Chief Justice of India that next week some decision will be taken. Like, as you know, Delhi High Court has already taken a decision that the court's work will remain suspended till 12th of June. So I hope that we may be able to convince the judges and the decision makers, and the court work may start, if not in the first week, definitely in the second week of June. So my dear friends, life is going to be redefined now, and professional life is also going to be redefined. Let us brace up to march forward with the endurance and resilience. Thank you very much. All the good wishes to you. Thank you very much.
Thank you so much, sir, for...
I can take questions, but after Sanjay has spoken, we can take questions.
Sir, definitely, sir. Sir, from here, I would request Sanjay Rathi, sir, to take on from here and express his views about the topic of today, sir. Sanjay Rathi, sir, over to you.
Yes. Good evening, Ved Prakash Sharma Ji, Co-Chairman Bar Council of India. My fellow friends, Nitesh Mehra, Amit George, Mayangar, Angel Bhardwaj, and my all viewers of today's webinar. As we all know that during this pandemic global which we are facing it, we all are required to maintain and adhere the safety to lead our normal life. And I pray for that we all should do that in positive manner. So now coming back to today's webinar, which has two parts. As initially it has been detailed as plight of lawyers during COVID-19, and the second part, effectiveness of virtual hearings. As it has been stated and elaborated by our Co-Chairman Bar Council of India about the situations of the advocates during this period and how the difficulties they are facing during this pandemic, where all the country, where the courts are closed, there is no court functioning, and only in context to the urgent matters, the cases are being taken up. So in that situation, but obvious, the sufferer is the advocate only, as they have no work. The main plight, if we consider, and we see on evaluation that without work, the condition of an advocate, that itself comes and falls in the ambit of a plight situation. Now, this situation of non-functioning of the courts, which directly affects the officer of a court who is an advocate, which certainly comes also with the position that the financial earning also stands completely with a hurdle, that there is no assistance in connection to the finance to each an advocate. And such financial assistance, when not there with the advocate, it would affect the mental health, it would affect the running of a house. So these issues, because of non-functioning, clearly brings an advocate in the ambit of a plight situation. So I, being member of a bar council of a Delhi state and holding a position as a co-chairman, and respected Ved Prakash Ji, who is also representing Delhi in Bar Council of India as a co-chairman. So after deliberation and discussion, in order to bring out our brothers and sisters who are needy, who could be provided with some financial help, although that help which we have initiated may not be an adequate help to them, because our brothers and sisters, when they were working during the normal course of their time, when the courts were functioning, each were earning his livelihood with the honor. But now, because of this global pandemic, they were not able to earn. And we have decided, as it has been stated, the figures which have been given, that near about 9 crore rupees from Delhi State Bar Council is going to be allotted. And out of that part money, near about more than 3 crores, it has been distributed among us, the lawyers. So the basic situation in this, in connection to our first issue, the young lawyers who are opting for their career, that also comes to an obstacle position, that they can't have that sphere of time to learn for that. So they are also withdrawing themselves. Although they were having all new technology with them, but because of this hurdle, as they are not able to have that knowledge in connection to the physical work which the junior advocate or a new advocate used to come and hear and see from the courts. So because of that, non-having of a work is directly connected with the plight of an advocate. So other advocates also, who are having their regular practice, but are now at this point of time, for the last near about 3 months, they are also not without work. Although they can sustain their houses, they can sustain their kitchen, but in the absence of work, again, it is a question that it is a plight of an advocate. So in connection to this first issue, that this COVID-19, it has suffered, as stated, it has been elaborated, not only our country, but throughout the world. 213 countries are affected. And it is, this profession is badly affected, and our advocate brothers and sisters, they are suffering, and this situation is to be met out, for which at each point of time, by making representations, we are also following the Honorable High Court. We are making representation to the Chief Justice High Court. We have also wrote to the Chief Justice of India and to government authorities that this position could be made undone by finding some positive solutions. So apart from that, the second issue, which is also a very vital issue regarding the effectiveness of virtual hearing. I little differ from my respected co-chairman, Shri Ved Prakash Sharma ji, although at each point of time, we are also of the view, it has been noted and represented by the Bar Council of India also, that physical hearing of the matters, physical opening of the courts, that have its own grace, that have its own, we can say that in dispensation of justice, it has its important value. Those valuable considerations are there, how it is to be cogitated, the person, the personality, the cases and all that. But now in the present situation, there may be some of the cases regarding where in criminal matters, the evidence is recorded, TIP proceedings are there. But as of now, and from now onwards, as we are for the last near about a decade, we were dragging this position for adapting the new normal, for adapting this new technology. But now the time has come. Our young brothers who are doing practice, who have started practice, or the law students who are in 4th year or final year, they all are well versed with this new technology. And we, the lawyers who have crossed or who have practiced near about 25 years or so or about, we have also to learn it again, that this is the new technology for which we have to sustain with it. So to adapt this, it is very good. But in this, the basic requirement, the basic elements which are required to be noted, which are required to be evaluated, the basic infrastructure is required to be provided. On that score, the responsibility lies with the state government, the responsibility lies with the central government, the responsibility lies with the Honorable Supreme Court and Honorable High Court. That where is that infrastructure? So if that infrastructure is provided, this new technology would certainly help in speedy dispensation of justice. And further, we can see, we have instances as a pilot project when it was started in connection to the remand of the criminals. So it was started, and nowadays, all the functionaries who are connected with that system, that is working, either he's a judicial officer or he's a police or he's an advocate who used to participate in. Now, that technology, that pilot project, that is sustained and it is viable and now moving without any drawbacks. So for the time being, if we started, and latest this the traffic challan courts are being initiated, that is also working. So once we will adapt ourselves and involve ourselves, we will learn. So all these situations would start making us that we can help in filing all these things. We can help with the new technology so that the things could be done. So what I want to add, that there may be certain cases in which physical hearing is there, even though last, I think 6 days back, our judge from the Honorable Supreme Court, Honorable Justice D.Y. Chandrachud, who is also chairman of E-Committee of Honorable Supreme Court, who is looking after this functioning of E-courts, creating all these new technology, in the views of Lordship also, where they have created a software called SCI Interact, and they want that all 17 benches in Supreme Court would be paperless. We are also there, and we have seen that even in our own High Court, there are few courts which are running paperless. So all thing behind is that these situations arises when there is a good infrastructure. And Honorable Supreme Court, Honorable Judge has also taken into position that the lawyers, who are the main pillars of dispensation of justice, they are to be taken into confidence. The basic knowledge of regarding this new technology is to be provided to them. Then only it can be sustained. I feel that when the Honorable Supreme Court or Honorable High Court is doing for them, they are maintaining that the new tablets are being provided, new infrastructure regarding creating these e-courts are being provided, then why not lawyers? Why the lawyers are being ignored? When we are the officer of the court, we are the part who used to help in dispensation of justice. So similar infrastructure is to be provided. I can say that lawyer who is there to fight for the rights of others used to provide justice. So in that situation, we are ready to adapt with this position. Our Bar Council or Bar Council of India, these are the institutions who may not have that much of funds which could be said that this situation or this infrastructure could be created by them. When the officers of the court, the judicial officers are provided with that infrastructure, with similar ratio, it should have been provided to the each advocate who want to practice, who want to come forward in this legal profession. Unless the infrastructure is there, nothing can be done. One day the situation will fall. This virtual hearing, its effectiveness, if we want to improve, then certainly we have to be with this latest technology, latest infrastructure. As stated by in the views of Justice Chandrachud, it has been opined by him, and he had agreed that open court hearing is one of the fundamental precepts. And further, it was added that it has been stated that virtual court will not displace the open courts. They cannot be substitute or panacea for open courts. So this view, when is already within the knowledge, within the mind, then for opting all this infrastructure, why we should not come with collaborative issues by joining hands that this is the infrastructure which could be provided. I have an instance which this signifies the effectiveness of virtual hearing. As in one of the district court, even in my present, when I was present there, I have seen that while the virtual hearing was started, the court master of a court is putting his mobile by saying that you are on the line. The judicial officer is hearing his argument and then putting him on hold by saying that what is the objection from the prosecutor. So such type of virtual hearing, if we will allow to continue, then certainly it is a failure of justice. We are doing injustice to that client for whom the judicial officer was listening that matter. Another instance I have, now for this virtual hearing in district courts, it is completely not adhering what is required to be done. Suppose I had a matter, I had to fill a form, and a coordinator who is between me and the judicial officer, he is going to decide whether it is an urgent matter. And if it is not urgent matter, it is being dismissed without hearing me. So the coordinator cannot be said to be a judge. I had to explain the urgency. I had to convince the judge. So for that, what is required? Again, the basic thing is that from the first level up to Supreme Court, we are sitting idle for the last 3 months. Infrastructure is to be given where it should be displayed that the judicial officer is sitting, defense counsel is arguing, the opposite counsel is there, the complainant counsel is there. Let open deliberation should be there. Why we are sitting? What government has provided? So we should not talk on papers. Honestly, we all have to come out to make sustain this effectiveness of virtual hearing. The government has to provide a special budget. In last 3 months, if we talk about the capital of India, where we have 6 to 7 district courts, none of the one court has been taken up that this special jurisdiction qua the rent, motor accident claim. So these courts, if we could have taken 5 courts from each district court, we could have ordered for scanning those files. Those scanning material could have been provided to an advocate of both the parties, to the judicial officer, strong bandwidth connection, strong internet facilities. Why we are lacking in all this? Why the authorities who are concerned, who are sleeping over it? Because it is required to be done. That willpower is required to be maintained in order to make this substitution of virtual hearing from the physical court. Now, in the present scenario, if you want to opt, it is a good new technology. We can do it. There are a number of cases, number of initial part of the litigation. Nowadays, e-filing is being done. But in the matters which are already pending, those matters can be get scanned and those things can be provided as I stated. So in order to initiate or to head a speedy justice, suppose an e-filing matter is there. Why we should not provide, we could have the directions, we could have the law amended that the pleadings chapter or the initial stage up to the, like in a civil matter, up to the framing of issues, it can be done by e-way, the notice has been issued. By e-mode, the written statement will come, the replication will file, the issues of both the parties. So up to that stage of hearing, in order to make more effectiveness in the system, more effectiveness of these virtual hearings, only what I feel in civil litigation, only at the stage of 3 or 4 times we can be before the court. Otherwise, the advocate who is fully competent, who want to do work, who want to learn this technology, who want to face the challenges. So all these things can be get done, and the advocate is always ready when the infrastructure is provided. In order to conclude in connection to this effective hearing, what I say, that each professional who is taking this challenge, not alone, but along with the judiciary, to become the most primitive pillar of this digital India. So we can do, we have that knowledge, we have that mind, and we have that zeal to work for virtual hearing, virtual matter, and e-court system. So these are my submissions. The rest I over to you.
Yes, Sanjay sir, it was a very nice and informative session from you on both the parts of today's webinar, covering the plight of the lawyers as well as the effectiveness and ill-effectiveness of the virtual hearings which are taking place today. So I would now request Shri Ved Prakash Sharma sir, if you like to share, add in the same something, and thereafter we'll start taking the questions.
I just want to add about this virtual court. You know, we have seen these virtual court, digital courts, you know, only recently during this lockdown period. And as all of us know, the direction by the Supreme Court, by the High Court was that only most urgent and urgent matters would be taken up through virtual courts. And as I told you about data collection, which we have done in Bar Council of India, only 10% of the total pendency in our courts, they pertain to most urgent and urgent matters. And even those 10% matters were also not adequately attended to, addressed by these virtual courts. So there are so many, maybe some technical issues, some training issues, I don't know what may be the issues, but there are issues with it. And then what was the other direction by Delhi High Court? Let me come to that. And there are such directions by other high courts also, that along with most urgent and urgent matters, the courts can also do other matters with consent of the parties, with joint request of the parties. A specific circular was issued by Delhi High Court in that regard. I know of that. You must also be knowing about that. Now, what is our system? The system which we are operating under is a adversarial system. You know, in an adversarial system, there are two parties litigating with each other, and one of the parties definitely would be interested in dealing the matter, particularly in civil cases. Now, I have not seen even a single matter during these 65 days where both the parties have agreed jointly and approached the court that kindly list our matter in the virtual court. Both of us are ready to argue the matter. Both of us are ready. For example, you just imagine about a rent matter. In a landlord and tenant dispute, would a tenant ever agree to the request of the landlord for taking up or fixing the matter before the virtual court? So my experience, I do agree on some points with my dear friend Sanjay Rathi, that e-filing, it's okay. Even with e-filing, we have been appearing before the traditional court. Even paperless filing, I agree with him. Save paper, let there be paperless filing. But with paperless filing also, we have been appearing before the traditional court. So unless we have a system in place, infrastructure in place, proper training in place, and we have a community, our legal fraternity, ready to take up the challenge, it won't be possible. But our legal procedure, our law of evidence, civil procedure code, criminal procedure code, there are issues where many matters will not be covered under the category of virtual court hearing. It's not possible. Either you change the law or you have to go with the traditional courts. So there can be points for or against, but my feeling as a lawyer of 45 standing, particularly working in the trial court, is it concerned, my feeling is that no, this is not the time for us to be ready for this virtual court system, and the 65 days time during which the courts have functioned through virtual court, even most urgent matters have not been rendered proper justice. As far as listing of the matter is concerned, as far as hearing of the matter is concerned, technical glitches come in between, the hearing goes a complete waste, and the matter is fixed to some other date. I mean, there have been so many instances which we have been given input about, that even these virtual courts where the parties start arguing the matter, so many issues crop up. Sanjay has also spoken about that. So I don't think that we are ready for that, or our law and procedure is also in a position to permit that kind of a virtual hearing, lock, stock and barrel. Yes, on a limited scale, as Sanjay has said, in challan matters, Justice Chandrachud opened that court and inaugurated that court. It is possible when there is no contest from the other party, the accused, the challans can be disposed through virtual courts. In remand, these things can also be addressed too. But the court system, the justice dispensation system today is not fully ready and geared up to accept this digital court. That is my view.
Thank you so
Any
much.
question?
Sir, yes, sir, yes. We would be taking first you, sir, for the 5 minutes extra, as you said to be finished by 5, but we'll be taking 5 to 7 minutes extra, sir. So Ved Prakash Sharma, sir, we request you to be there on the board for the 5 minutes. So what I gathered now from both of our speakers for today, that sir has rightly said, Ved Prakash Sharma has rightly said that our system is the adversarial system, and the system cannot work when both the parties would agree to contest on one matter. So what we have otherwise gathered from the still words of the bar, that firstly facilities, infrastructure shall be provided to the lawyers. Then only we can think of the effective hearings through virtual hearings. And practical hearings, difficulties, yes, we have all witnessed that what all has been taking place because of the lack of the infrastructure. So, sir, yesterday,
Mr. Nitesh, I want to add a small answer to
sir,
your earlier question.
Sir.
I agree with the substance of the question, and from tomorrow onwards, I will put it forward within our council that young lawyers, they would be called to educate that how the system is to be taken off, how it is to be learned. So for that, whatever remuneration, whatever charges we could pay to our young lawyers, so in order to support them, and we will get the knowledge. So it is a very good platform which we will try to initiate, and positively it will be get done, that at least this technology could be adapted by learning from our young lawyers.
Sir, not praising our platform and the board, sir. Today, I would like to add only one line in this, sir. Yesterday, I had a word with District and Session Judge Headquarters, Tees Hazari, and we had talked to him to provide one judicial officer to explain a procedure of e-filing, and they have readily accepted and agreed to it, and we have been given a day by them so as to provide a system for procedure of e-filing learning through PPT presentation by a judicial officer. So, sir, we are also thankful.
And we have, Nitesh, we have also wrote in this connection that in each district court, a projector or a big screen should be provided, which disclose step A, step B, step C, so that
Definitely.
our advocate brothers they can see, they can
Definitely.
proceed it, they can sit and learn from that. So
Yes, sir.
it is to be get done. We have already written in this connection.
So, sir, the second question is to you, sir. Quickly coming to the second question, Sanjay Rathi, sir. If the courts are open, what precautions will be taken by the bar associations to safeguard advocates, litigants, and other staff by Amit Sharma Advocates?
First of all, as I stated in my earlier webinar also, that to some extent the entry of public should be stopped. Apart from that, sanitization tunnel should be there. At each 100 steps, we should have sanitization stations. We should have all, as I stated, that if it is possible, glass court system could have been there. So collaborative, we can do it along with the judiciary, our bar association, our bar council, we all can get it done. So in order to have a personal safety of an advocate, even of a litigant, even of our judicial officer and court staff, this distancing is to be there, this sanitization is to be there, mask is to be there. So we should stop of sitting in canteen. We should not gather together at one place. So these are the new few steps which we could adapt, and we should follow it in order to avoid this pandemic.
Sir, another question is related to the virtual hearing. So
Nitesh, just one addition to the question which you have put to Sanjay.
Sir.
As far as this precaution is concerned, you know, as all of us know, the footfall, particularly in district courts, is not less than 30 to 40,000 in all the district courts. In the High Court also, there is a lot of crowd, and Supreme Court, people are walking shoulder to shoulder. So what we have suggested to the Chief Justice of India for district courts particularly is that in the beginning, you list only most urgent and urgent matters and make it optional. You know, people can have it in the virtual court. They can have it in the traditional court also, and don't list more than 10 matters in the beginning, say for 2 weeks. And don't allow litigants to enter the court complex. Only allow the advocates. They can go to the court. And if time slot can be fixed for a particular case, which is possible, if the court has in place just 10 matters in a day, time slot can be allotted to the particular matters, and the advocate will go to the court at the particular appointed allocated time slot, and he will make his submissions. The questions of social distancing will become quite easy to follow. Then secondly, yes, you refer to bar association. Bar association has a very big role to play. As far as now, suppose courts are going to open in second week of June, of course, to a limited kind of extent. So the bar association should provide volunteers who will, take care of these norms, this protocol of social distancing, kind of sanitizations and all other things. And suppose clients come there, they should not be allowed to go to the court building. A hall or things like that, they can be utilized for the clients. In some cases, the presence of client is necessary by the court, he can go to the court. So the volunteers and these bar associations will have to play their role in order to ensure that the protocol of this social distancing, mask, etc., it is fully followed and adhered to. And after 2-3 weeks, we can review the situation, find out the areas of deficiency, and we can remove all these issues of deficient issues, and then we can march ahead.
Certainly, sir, the process has to be initiated as we initiate the strikes to see that how practically they have been affected. So we have to see that our bar leaders may take steps in this regard for implementing the social distancing by appointing the volunteers in this regard. So, sir, another question is there. Sir, this is a question from Divyansh. Can BCI, that's a Bar Council of India question, sir, over to you, Ved Prakash, sir. Can BCI undertake online training of lawyers through YouTube channel and other social media means to empower them about technology? And also, can BCI work with government authorities to improve technology setup in courts for improving the functioning of e-courts as has been stated?
Yes, definitely. The Bar Council of India would be happy to provide any kind of help or any kind of training programs. We have already been doing all these things. BCI is active because we are regulator for legal education as well. So we get students, a lot of students, and these young students are very apt in this technology. And in Bar Council of India auditorium, once or twice a month, we are holding, these continuing legal education sessions, and we have already held such, for example, e-filing. We have already held these training programs of e-filing and these paperless work, and we have been promoting it, and we would be happy to provide our assistance and cooperation in this regard. And I will definitely put forward this point to our council, and we will definitely, because it is going to become a need at least to some extent, if not to the whole extent, and we will definitely do our bit, whatever is possible by Bar Council of India to do in this regard.
Sir, having heard this answer from you, I think many of us has been satisfied that Bar Council of India has been taking every possible step to minimize this pandemic situation which has arisen, and because of which lawyers have been facing with the mercy plight which they are facing. Another question to Sanjay Rathi sir. Sir, there is a small question which they say that can high-speed internet facilities in the lawyers' chambers assist in effective functioning in virtual courts during the COVID-19 pandemic? Sanjay Rathi sir, over to you.
Yes, I had stated in my the conveying of the issue, which is of our today's topic, that high-speed connections, internet connections, strong bandwidth connections, these are must, because the rhythm of an advocate who is while process, who is in a session of his cases. So if there is some technical fault or breakup, so the flaw, the words which you want to convey to the judicial officer to convince him, so that break certainly would cause injustice to the clients. So this is the basic element which have a very vital role. It is to be maintained. Since inception, we are hearing when this technology came, we are giving it to Delhi. It is coming to each corner. Nothing is coming. Honestly, we had to adhere this, and that is must and essential for us to get it done in order to have this affecting virtual hearing in the matters.
Yes, sir, that was a very appropriate answer for the said question. Ved Prakash Sharma sir, this is a question to you, sir. Being a master of the civil laws, sir, don't you think that, sir, it's a very good question. Don't you think that e-filings, which are now not attested by the oath commissioners, will the parties will be bound by their statements, and will not there be a plethora of cases which would now be resultantly be arising out of these, where the parties say that they have not said on the oath? Sir, over to you, sir.
Yes, that is why I mentioned, while I was making my point, I mentioned about our present law and legal procedure. No, the Civil Procedure Code, it provides about verification of pleadings. It provides about affidavit, and there are certain norms, how a affidavit is to be sworn, and how the affidavit, for example, if it is to be attested by a notary, it requires authentication. But with these e-filings, this will not be possible to follow all these procedure of law, and areas of dispute definitely will arise because of these e-filings. But then the High Court is all pervasive in these matters, and the High Court can definitely make rules. High Court can amend the CPC, can make rules with regard to Civil Procedure Code. You must have seen hundreds of kind of rules have been made by the High Court in Civil Procedure Code. Implementation in a particular state, you will find different rules. So High Court can do away with all these areas of difficulty. Not a big issue. It's not a big issue. The High Court can issue a notification that these attestation of affidavit, either by oath commissioner or by a notary public, these would be the norms. And when there is a e-filing, no area of dispute will arise, and the High Court can definitely do away with these kind of compulsions in the procedure.
Sir, not taking your much time.
Nitesh,
Yes, Sanjay,
I
sir.
want to add one line answer to it.
Please, sir.
for this virtual hearing and e-filing and all that which has been asked, the software comprises all these issues. There an affidavit or the verification, as Ved Prakash Sharma sir has said, that once all these software do comprise this situation, that the scanned copies of those affidavits, those can be filed along with the e-filing after getting it scanning, because the software which is going to be developed, they have that area. It comprises of that situation. So in order to make security in that connection regarding the personality or a person or an individual, it can be taken care of.
Thank you so much, sir, for adding in the same. And with not taking much time, as the time is very precious of the co-chairman of Bar Council of India, at the same time the co-chairman of Bar Council of Delhi, who has given their efficient time today, and they have given all the answers very firmly, understanding the questions and the real practicalities and difficulties faced by the lawyers in this pandemic. Now I giving it over to you, Mr. Angel Bharadwaj. I request you to give a thanking note to both our steelwards of Bar. Mr. Angel Bharadwaj.
Yeah, thank you, Nitesh. What a wonderful webinar. What I don't know, even I was, while drafting the thank note, I was taken aback by having such big stalwarts of the profession. But now that I have the privilege to give the thanking note, the COVID-19 lockdown has affected all walks of life, including the judiciary. Courts all over the country have mandated strict imposition of social distancing, restricted the entry into their premises, and limited the number of cases being heard to the extreme urgent matter. This has had a deleterious effect on many young and independent lawyers. The crisis in judiciary has brought to the fore disparities in the income in a profession that is otherwise seen as lucrative. While senior counsel or the advocates practicing for years and employees of the law firms may not be hit that hard, but otherwise the lawyers who depend on daily practice, daily appearances, these include number of enrolled new advocates and their independent practice and their junior associates who have been denied their salaries. Lawyers who depend on fresh filings have no source of income other than new cases to be filed. I would say what a wonderful session. It was indeed a very helpful webinar. Thanks a lot, thanks a ton, Shri Ved Prakash Sharma ji, Shri Sanjay Rathi ji. Thus, discussion was tabled since the onset of the lockdown and closing the courts due to the spread of COVID-19. We were fortunate enough that our community of advocates today were addressed by such experienced and eminent knowledgeable speakers. This webinar has in effect brought a lot of relief among the advocates, as I can see by the question and answer round, and settled many questions in their mind due to the virtual hearing and the advantages as well as the disadvantages of the same. Thank you again, sir. Last but not the least, I would like to thank our participants who could spare time and attend this webinar. I sincerely hope we have achieved something with the topic, today's topic. Thank you, everyone. Thank you again, sir. Over to you, Nitesh.
Thank you.
Thank you, Ved Prakash Sharma, sir. I would like to make a final thanking note to the Ved Prakash Sharma ji, Co-Chairman Bar Council of India, and a thanking note to Shri Sanjay Rathi, sir, Co-Chairman Bar Council of Delhi. And I would also like to extend thanks to my associate for today, Mr. Mayank Garg, Mr. Angel Bharadwaj, and Mr. Dr. Amit George, who have helped me in conducting the today's webinar. Thank you, all of you, very much for today's webinar.
Thanks a lot.
The same would be circulated to you all in the YouTube link also. Thank you very much, sir. Thank you.
Okay, welcome.
Thank you, sir. Thank you, Nilesh.